because some suppliers were saying through no fault of their own, it was impossible for them to deliver the services or the goods as promised. And as a result, they were not even in a position to refund consumers. So we issued a press release on the matter, and in a lot of complaints, we were successful in resolving and enabling consumers to be refunded. In the last year, we were able to get consumers to be refunded more than 7 million in refunds. So what we thought we should do is that we should bring in an expert who would consider the issue and give us clarity on some of the questions that arose in our organization and also in the public in general, in terms of attorneys or consumers who were faced with these issues. So I am very happy to say that we have Ms. Noluthando Muledi, who is an admitted attorney and holds an LLB cum laude from Wits University. I'm also a vet, so I know vets guys, we are the best, I tell you. She also has an honors in a Bachelor of Science from UCT and also a BSc from Mount Holyoke College in the US. I hope I pronounced that correctly. She is currently the co-head of the Corporate and Commercial Department of Tambo Scott Attorneys, and she served her articles at Bowman Gilfillan. She also has international experience, having served as a policy advisor for the World Bank, and she played a key role in negotiations on issues of development finance. She is fluent in French, and she's also a member of the South African Institute of Translators. So as the CGSO, we thank Noluthando, who agreed to do this presentation for us. And having looked at the presentation, I think we are all going to benefit. Welcome, Noluthando, and thank you so much. I hand over to you.
Thank you so very much for that very warm welcome. And welcome to everyone who's here this morning, and we thank you for availing yourselves and giving us your time. I very much look forward to having a robust discussion. I would like just to request that you hold your questions off until the very end, after which we will, have, I feel like, sufficient time to go through all the questions, to dialogue, because I think this COVID and the resultant national lockdown has presented some very unique legal challenges and has made us, think differently about the law and ways in which we draft our legal contracts, etc. Ma'am Magauta, may I ask you to project the presentation? I think she has introduced me better than I would have introduced myself. And I just wanted to
Noluthando, you are mute.
Have I been mute the whole time? Apologies, I thought I had unmuted. I hope.
No, it was just a few seconds.
It was just a few seconds. Apologies, I don't know how that happened. Okay, just a quick introduction. We are, you can go to the second slide, ma'am. We are a commercial law firm, and we do the full suite of corporate legal services, from M&A transactions to your, what would be banking and finance, your loan agreements, etc. We advise on the Consumer Protection Act, and more recently on the POPI, with it coming into force on the 1st of July. So that's just some background on who we are. Apologies, there seems to have been the lighting going off in the building, but I hope you can still hear me. And how I'm going to do the presentation, I'm just going to start with a general background on just the general theme of whether, COVID and whether we can raise the defense of force majeure. And then as we proceed, I'm going to hone in quite specifically on, force majeure and the Consumer Protection Act. And as Majeure has stated, some of the defenses that have been raised in terms of Section 47.3 more specifically, and, dialogue and see what the law says about things like the obligation to pay refunds. Yeah, and I think she has already also given us the background, and I think it is an important background because it kind of sets the scene of where this discussion is coming from. So we all know, that we had the World Health Organization declare COVID-19 as a pandemic, and that resulted at the national level with a closure, as we all experienced through much of last year and some of this year, closure of retailers, restaurants, businesses, etc., which, for all intents and purposes, made it physically difficult and in some instances impossible for businesses and individuals to meet their obligations under contracts. In these sort of circumstances, we could potentially raise a force majeure, but legally, force majeure has a legal definition and has specific circumstances that need to be met in order to raise this defense. And I say this just to caution, businesses and individuals from just raising or being too quick to raise the defense of force majeure. Because if you're raising it in a legal sense, it might not have applicability in your particular set of circumstances. And just, we have a variety of people on the call, and just to make sure we all, on the same page in terms of understanding legally what is meant. Apologies to those for whom it will be a repetition. But in the business sense, when we talk about force majeure, obviously it has a literal French translation of a superior force. But in the business sense and in a legal sense, it describes those uncontrollable events. So the events that are truly beyond our control and an ability for us to have foreseen them, such as, war, political unrest, strikes, riots, extreme weather conditions. We'll remember, the tsunami a couple of years ago. I think it was, in Bali. I could be wrong, but we'll remember that, explosions, the so-called acts of God, and more recently, pandemics that resulted in, national restrictions of movement of peoples. And as already mentioned, these events are not any fault of any particular individual. And the effect of a force majeure clause, the legal effect is that it provides for a temporary suspension of parties' respective contractual obligations upon the occurrence of a specifically defined event. So usually when we draft contracts, we will have a definition of what those events will be. It can either be a closed list, or it can be crafted in a way that kind of when it's interpreted, can include various forms of incidents and events. The other party to the agreement is usually prohibited for the duration of the force majeure event, i.e. for the year of COVID or the national lockdown or the 3 months of the strict lockdown, for example, from instituting a damages claim as a result of the first party's non-performance. And I think this is really important to emphasize that the effect of raising so ordinarily, if you don't perform in terms of a contract, you would be liable to a damages claim for non-performance. So the effect of the force majeure clause is to mitigate and relieve the ordinary repercussions of your actions, and would alleviate and would prohibit or restrain the other party for bringing a damages claim, which is different from a refund. We will discuss that later when we go specifically into this as CPA, but I think this is important to highlight that it prevents the other party from instituting a damages claim based on non-performance. It should be noted, we can still be on the previous slide, please, ma'am. So it does not automatically apply to a given set of circumstances. And I think I had mentioned that before. We would have to look at the contract. And if it's not defined in the contract and the common law applies, we would have to apply the very stringent objective test of impossibility. Next slide, please. And as I mentioned in my last sentence, so if there is no force majeure clause in your contract, we would apply the common law doctrine of supervening impossibility. Of supervening impossibility. And how this doctrine is applied is that there's a test, and it's an objective test, and it's quite stringent, the test, where we look objectively whether it is impossible to perform in terms of that contract. Next slide, please. And for the South African doctrine of supervening impossibility to be applicable, the impossibility must occur after the conclusion of the contract. So it must be unforeseeable. And at that point in time, you must not have been able to foresee that, i.e., there would be COVID. Because if you would have been able to foresee, you would have had to take steps to mitigate. You would have been under an obligation to take steps to mitigate. The events must objectively impede performance. So it must be a third party, an objective third party looking at that circumstance must also be able to conclude that that performance would not be possible. So it's not a subjective test. It must, on an objective assessment, there must be evidence that you would not have been able to perform. And if performance becomes objectively or absolutely impossible, the contractual obligation is extinguished, and the duty to perform and the corresponding right to claim performance will fall away. Objective impossibility includes instances of actual physical impossibility, i.e., you cannot actually render the service, and also where performance remains physically possible but cannot reasonably be expected to be performed. There's a tsunami, you're an engineer, yes, you could go out and build, but there's no reasonable expectation that you would do so or that you should do so. Both parties' obligations to perform the contract are then extinguished, as I said, and if the event causing the impossibility was foreseen or foreseeable and could have been avoided, i.e. there's steps you could have taken to mitigate or to cater for that circumstance, then the parties cannot rely on this doctrine to not perform their obligations. Next slide, please. And now coming to the specific ambit of the CPA, as Mehauda shared with us in her introduction, which is the context in which, it was being raised to them as the Ombud. And in reality, we all know that, COVID-19, the resultant national lockdown, created uncertainty with both consumers and suppliers in respect of their contractual rights and obligations, and more particularly their rights and obligations in relation to cancellation, postponements, refunds, lease agreements, etc. And in March, actually it's 2020, it was last year, the Office of the Consumer Goods and Services Ombud released an official statement, i.e. outlining their particular position, in terms of which they made it clear that consumers would have a right to a full refund in circumstances where they were unable to take up a booking, a reservation, follow through with, some kind of commitment that they had made, travel, etc. And this position is in line with a position under a common law, which provides that if a consumer has paid in part or in full for services to be delivered on a material specific date, and the supplier is unable to deliver on that date, consumers will be entitled to a claim for repayment of the monies paid unless the terms and conditions of the contract state otherwise, or the parties have amended the contract and have made alternative arrangements in terms of their contract. And where the contract is silent on the cancellation policy, the supplier is not entitled to refuse to refund the amounts paid to it, or to advise that the service will be delivered on a later date to be agreed. And it was shared earlier that a lot of consumers and businesses were relying on Section 47(4) as a defense and raising the defense of force majeure. And the CPA permits the supplier to raise a defense to a claim for a refund if the consumer unreasonably rejects an alternative offer to satisfy the promise to deliver. So the principal position is you would be under an obligation to repay, or to offer the consumer an alternative, either, tokens or credits, and the consumer could not unreasonably deny your request. And in that instance, if they unreasonably deny your request to make alternative arrangements, then in that instance, the service provider could raise a defense. But it's not a blanket no refund policy. There would have to have been effort by the supplier to find alternatives to satisfy the consumer. And yeah. I think we'll just skip this. It just was summarizing how far we've just come, i.e. outlining the common law position, outlining the legal position, and just bringing everything nicely tied down, tied into one slide. So we can just move on from this one. And so just, in addition, I think it's important to remember that ordinarily, as I mentioned previously, that the force majeure would relieve a party from a potential damages claim, but it does not absolve the supplier from refunding a service a customer where a refund is due. I think we can move on to the next slide. I just wanted to share some, legal principles in some cases. This is a very recent case, and it was actually a case in which a restaurant owner had employees and who were required to be paid, and it turns out that they had permission actually to continue to trade, but the restaurant decided not to, because the conditions under which it would have to be trading would render the business unprofitable. And as a result, they were not able to then pay their employees and wanted to raise the defense of force majeure. So right at the outset, I think in the first or second slide, I cautioned, in the legal fraternity, we caution, I suppose, businesses and service providers for being too quick to run to the defense of force majeure. And I think this case, really aptly illustrates, an instance where a business was unable and unsuccessful in its reliance on the force majeure defense. So what the court held, so firstly, the court highlighted the general principle of how the common law rule of impossibility is applied. And secondly, I highlighted it in the subsequent slide, On assessment, the court held that no, it wasn't impossible for the restaurant to perform. They decided of their own accord for business reasons because it was inconvenient, it was economically onerous. They made the decision not to trade, it wasn't profitable, etc. But because of a decision they made, they couldn't then want to rely on the defense of a force majeure in order to pay their employees, and they were ordered to do so. So, this is, as all good attorneys will say, it's on a case-by-case basis, and the courts have emphasized that, this either, the doctrine, the interpretation of the clause within a contract is really done on a case-by-case, and it will have regard to surrounding circumstances, looking at the position thoroughly of the person trying to raise the defense. Was it objectively really not possible? Were there other ways in order to meet that that the person could have undertaken to meet the obligation? So it's really it's a factual inquiry. It's assessed on a case-by-case basis, and courts test and thoroughly interrogate. Were you truly, as a result of this incident, not able to perform? Were there other plans you could have made, etc.? We can go to the next. Mechauta, you can skip over to the next one, sorry, because it's the same case. I was just highlighting two different. And this is an older case, but it just, here I was just illustrating how, again, how courts look at the doctrine of impossibility. And in this particular instance, it was in relation to a payment of monies, which I think comes up as well, with debts due and individuals unable to meet their obligations for various reasons. But here the court held that if contractual performance becomes impossible at no fault of the debtor, the contractual performance will be extinguished. However, this rule is not absolute, and consideration will be given to the particular contract between the parties, as I had already mentioned, the nature of the contract, the relationship of the parties, circumstances of the case, as well as the nature of the impossibility. So as I previously mentioned, the courts will not only test, the defense, but will look at surrounding factors to really interrogate whether there is really an impossibility at play. Next case. I also just thought it's interesting to see how in different jurisdictions the doctrine has been applied, how courts have dealt with this, the effects, the legal effects of COVID, and the attempt by either service provider or consumer to cancel a contract and to be absolved of their contractual obligations. So in this instance, it's an American case. There's an art dealer. He had a contract with an auctioneer to sell a painting at an auction in New York City. The auctioneer canceled the auction and terminated the contract after the governor declared a state of emergency, similar set of circumstances, I think, to what happened in SA, and issued an executive orders for the prohibited non-essential businesses to operate due to COVID. The art dealer subsequently sued the auctioneer to enforce the contract, but the court summarily dismissed the case as a matter of law based on the contract's force majeure provision. So in this instance, the parties actually had a force majeure clause in their contract, and it was crafted in a way that could be interpreted to include circumstances and instances that were not specifically mentioned by name. So, the art dealer wanted to allege that the clause didn't specifically say pandemic, but the court held that there was sufficient specificity in how the clause was crafted, that it was reasonable to say that it included the pandemic. So in this case, the auctioneer was successful in raising the force majeure, And specifically, I think, particularly, I think, because, the contract was well drafted. And I think the underlying message as well is, what we've learned just over this past year and a half is, to carefully craft contracts. No one could have foreseen COVID, but if, your contract is crafted and drafted in a manner that includes things we haven't even thought about, it makes it much easier to raise a defense than when you're trying to, overcome the stringent requirement of supervening impossibility. This is another case, a landlord case, which I think might have, I know it may not have been in this particular instance, but I think has come up in the last year a lot as well, last year and a half. Here, the plaintiff landlord and defendant car dealer entered into a 5-year lease agreement, and that contained a force majeure provision, but they had a carve-out. And in that carve-out, it stated, nothing herein shall be deemed to relieve the tenant of its obligations to pay rent when due. So yes, they had general, force majeure provisions, but where money was concerned, the landlord didn't want to budge, and they agreed. And the tenant wanted to raise again a force majeure, and the court held, that carve-out stands. You agreed, yes, on the force majeure provisions, but you also agreed on the carve-out, and the carve-out is clear. Nothing herein shall be deemed to relieve the tenant of its obligation. So the court emphasized the need to look at the intention of the parties in the contract, and it was therefore clear that the obligation to pay rent is not excused by the occurrence of a force majeure event. Next slide, please. So in summary, just to conclude, as we prepare for our discussion and questions, our legal position is that, as a result of COVID and the national lockdown and all the restrictions, the resultant restrictions, air travel, etc., no economic losses are claimable. So if you raise a force majeure, the other party would not be able to sue for a damages claim, but the consumer would still have a right to a full refund if he has paid, or the service provider would have to engage with the consumer to find workarounds and alternatives that satisfy the needs of the consumer as well. And the consumer cannot unreasonably just kind of flat out no. They would also have an obligation to engage. I think that brings us to the end. And we always have to put this disclaimer that, this is an information session. It is not a professional legal advice. As I mentioned before, these, cases are assessed on a case by case. And we often require all the facts to be able to, to correctly apply our minds and come to any kind of legal conclusion. Thank you for your time, and I hand it over to Mechauta to help us with the next part of the session.
Thank you very much, Noluthando. I think the important thing that we all need, that I am taking out from your presentation, and which we've always been saying to suppliers, is that the issue of force majeure, they cannot have blanket cancellation policies. The Consumer Protection Act places an obligation on the supplier to engage the consumer and agree on alternatives. And what we saw in the market is that the alternatives that were agreed on or that were offered to consumers were postponements and mainly vouchers, which also consumers could redeem at a later date. But we did have instances where consumers, for very valid reasons could not take up, for example, a postponement because, they were elderly and could not travel at a specific time. And we also looked internationally to see what other ombudsmen were saying. And you are correct that, and our view was that in the CPA, the remedies for force majeure are inbuilt, because if you look at 47, it says that if the supplier could not deliver because of, in the ordinary sense, if they deliver because of their own fault, the consumer is entitled to a refund plus interest plus consequential damages. But if it's not because of their fault, the consumer is not entitled to claim consequential damages. They can get a refund, unless if the supplier had offered an alternative and the consumer has unreasonably refused that alternative. I mean, the other section that we had to deal with a lot is the cancellation of bookings and advanced reservations, where a supplier is allowed to charge a deposit and charge a reasonable cancellation penalty where in those circumstances. But they can also not charge a penalty if the consumer is hospitalized or has died. So the issue that came up was whether the president saying at the beginning of the hard lockdown for you that you cannot go anywhere because you are considered, even without testing, to potentially have COVID and potentially be able to spread it to other people, you are sort of hospitalized. So we raised it that way. The other issue that we had to deal with was cancellations of fixed term agreements, because consumer would say, I'm paying the gym, I cannot go to the gym, and why should I continue to pay the monthly fee if I'm not accessing the service? So most of the big gyms, what they did is that they then froze the monthly service fees. But then what they did at the end of the lockdown, they extended the contracts by the number of months by which they had frozen. So consumers came to us and said, but how did this happen? Our view was that that is a unilateral change to the contract. You should have engaged the consumer to say, in view of this, we are freezing, and at the end, this means that your contract will be extended by so many months. So those are some of the issues that we had to deal with. And I suppose later, as we do these webinars, we will go deep into the issues. But maybe your just general view on those sections would be welcome. Sorry for putting you on the spot. And then after that, we will take questions.
Okay, I'll start with I think the cancellation one, I think we agreed, and I think I highlighted this a similar view to the one that you have highlighted, that the service provider would be under an obligation to engage the consumer to find alternatives. And so they too, the obligation falls on both parts, on the service provider to engage the consumer, and on the consumer not to unreasonably, say no, but where, as you say, like they raise a valid concern or a valid reason. I will be 80 in 2 years. I will no longer be to travel. I have hip surgery in 2 years or whatever, then they would be entitled to that, to the refund. On the issue of, for example, gyms, when I first did my gyms and their gym membership. So on the first 2 pages, I think, of the presentation, I think I explained that, the force majeure defense suspends the operation of the obligations, the dual obligations. So it doesn't necessarily, and depending on how the contract has been crafted, doesn't necessarily extinguish the obligations. It just suspends until such time that event has this, the supervening event has passed. So my understanding of where gyms were coming from is we suspending it for the 3 months of the hard lockdown, which is the time in which, there was the force majeure in place. Subsequent to that, the period falls away, the lockdown is lifted, the contract resumes, and the contract was a fixed term for 24 months. We will add the months that we were not able to perform at the end to make up the 24 months. I agree that, engagement, I don't know about all gyms, but I know Virgin did engage its customers,
yes.
did give them an option actually to, they had a position and they gave them alternatives if you want to exit. There were various options, I believe, because I was a Virgin then, and I do remember a dialogue. So they did their consumers. So I think it is good practice for, the consumer, especially under force majeure events, to engage their, customers. Yeah.
That is very important, because one of the things that we saw is that problems arose where there was very little communication, where suppliers were not indicating how they will deal with issues and how it would impact consumers. For example, one of the complaints that went through the roof were issues relating to online purchases. And for good reason, because of the lockdown, deliveries could not take place. But what suppliers had not done is that they had not indicated to consumers that the deliveries will be frozen. If you want to inquire, this is the number to call, or this is we understood that call centers were closed, but suppliers were not communicating alternatives to consumers to say, this is how you will reach us.
Yeah.
And this created a lot of anxiety on consumers to say, I've already paid money. What is going to happen to my delivery? And then what also happened after that is that when the lockdown was relaxed, then the promise was that we will deliver in 5 days. But even after that, the delivery did not take place and there is no communication. And I think what you are saying and what I'm saying is that there is a contract in place. Any changes to the contract, there needs to be engagement. Suppliers cannot unilaterally, even I think that's what I'm hearing you say, even in the context of the impossibility to deliver, they cannot just unilaterally make changes without engaging.
Yeah, I agree. And I think you make a very important point. Oh, we are both, yeah. And I want to underscore it. Like ordinarily in the context of when we draft force majeure contracts with force majeure clauses in, we put an obligation to the defaulting party in that instance to notify. So you would have to notify your other party that a situation like this, as per our contract, has emerged, which we have defined mutually as a force majeure event. It has now occurred, and I'm notifying you that I am unable to perform in terms of the requirements of the contract because of this event that we have now agreed constitutes a force majeure event. So the obligation to keep the communication channels open to notify the other party is there, I think, both contractually and in common law. So I think that is as part, I suppose, of your stakeholder engagements and information sharing sessions. It looks like, we might be with COVID for a while, and I think it's worth, and the economic repercussions are still continuing as we see. So I think it's something that is worth underscoring as we continue to do like the road shows or the virtual shows, informing, or making our suppliers alive to the fact that, please ensure that you are also communicating with your consumers and customers and notifying them of what is happening.
Yes, and I also think that you raised an important issue, that there is an obligation on the supplier to mitigate the risk. And I think those principles are also built into the Consumer Protection Act. For example, on the cancellations of advanced reservations and bookings, one of the obligations of the supplier is to show that they tried to find an alternative consumer, but we know there is a lockdown. You cannot find an alternative consumer because everybody is locked down. But I think the principle there is that you cannot just relax and saying you canceled your contract, I'm going to charge you 100% cancellation fee. It has to be reasonable. It has to look at the circumstances, and that there also there is an obligation to engage individually with the consumer. And I think the other issue that we said is that consumer contracts that fall under the CPA have no force majeure clauses. Usually it's business to business contracts that would have that clause. And of course, that means that we then had to rely on what the common law says.
Yeah.
Okay, cool. I think we can open for questions. Thank you. It's either you raise your hand or you submit your question on the chat box.
Okay.
Okay, there's a question there. Can I use the force majeure for a commercial space? I'm renting, currently struggling to trade due to the pandemic and have high areas towards the landlord. How then can I be excused from the contract without obligation to pay up money owed, or is there a future arrangement that can be made without affecting me legally?
Okay. Shall I take one at a time, or maybe 2 or 3? Or if there aren't any for the moment, I will just start with Daisy. Daisy is, it's a commercial space here. Daisy, as far as I know, there was, what is it, like a moratorium, or there was some kind of, what is it? Sorry, the word is escaping.
Moratorium on evictions, yes.
Yeah, but not only that, there was actually something put out by the government on commercial space. So I think, on commercial rentals and so on. And I think it would be worth exploring that. But ordinarily, just as I said before, force majeure is assessed on the facts. So there needs to be a demonstration that you were. There was no other way for you. There was no way that it was impossible for you to make rental payments. And if you are able to illustrate, either in terms of your clause, so the first prize is it in your contract, your rental agreement, is there a force majeure clause? That would be the first place to go to check what it says about force majeure. And if not, obviously, as we said, then we import the common law position, which is the supervening impossibility. But as I said, it's an objective test. So how that would be assessed is, was it impossible? There was no way for you to make other arrangements, other commercial decisions, not necessarily related to this particular business, but do you have other businesses? Was there any other way that you could have made those payments? And that is how the test would be applied. So if you are able to pass, so if there is no force majeure clause in your contract, and you have to then apply the doctrine of supervening impossibility, you would have to apply that test. And if you were successful in the application of that test, if on a whole, assessing your facts in totality, it was agreed by either the adjudicator or the court that truly you were unable to meet your obligations, then you would be able, your obligations would be extinguished from the time that supervening incident started, But if not, I think the best way always is, if you are not able to rely on a force majeure, not able to succeed in your supervening impossibility, then it's often, the most commercially, prudent way to go about it is to engage the landlord and see if possibly you can enter into some kind of arrangement or alternatives that can alleviate. So the first port of call is to look at your contract. Does it have a force majeure clause? If not, can you apply the doctrine of supervening impossibility? And if neither of those give you, success, I think, one of the proposal is engage, the landlord and see if there's a way that, he can extend your payment plans, he can reduce your payment plans, just see what the dialogue would result in. Yeah.
Thank you. Mr. Ryan Moodley, please switch off your video.
We sing the young one.
Yeah, I'm sure he's playing with the video. Ryan?
Any more questions? I don't see any in the
I see a hand, Mantombi.
Hello, how are you?
Fine, thank you. And how are you?
Okay, this is not Mantombi actually, it's Emmanuel Skosana at Consumer Goods and Services Ombuds. I'm an intern there.
Okay.
I have quite a long question, so please kindly bear with me. The question can also be directed to you, Ms. Makauta. I think either of you can answer it. So I want us to go back to, cancellation matters, right? Here, whereby we mentioned, okay, in terms of force majeure, when we, I think, look at the Glencore Grain Africa case versus Du Plessis, whereby the factors there mostly mention that the impossibility must be objectively probable. The impossibility must be unavoidable by a reasonable person. So going back to the section 47, subsection 4 of the Consumer Protection Act, which permits a supplier to raise a defense to a claim for a refund if the consumer unreasonably reject an alternative offer to satisfy the promise to deliver. Now, when we look at the unreasonableness, I want us to talk about the unreasonableness, because we find that, yes, suppliers provide alternative remedies, right? In most cases whereby
we lost you there.
Yeah.
Okay. When we look at, for example, I talked about remedies or alternative solutions that suppliers would provide to complainants. For example, if we talk about a gym contract whereby one of the complaints that we had, we found that a gym supplier mentioned that, you know what, let us not deduct full amount for that period of COVID-19. Let's deduct maybe, let's say, 50 or 40%, so that a contract can continue up until maybe the event of impossibility ends or something. So I want us to talk about, is there any reasonability test that we look at, right? To say, you know what, a supplier here tried, right? And a consumer now unreasonably wants full refund, right? Because, for example, if we look at the McSteel Services Centers case versus NOMSA, you find that McSteel, what they did there, they also did quite a few deductions to allow maybe workers not to be retrenched after the pandemic. And then they said, you know what, that is a reasonable step for a supplier to do in order to try and honor their end of their part. So is there any reasonability test that we have to look at in conjunction with Section 47, Section 4 of the Consumer Protection Act, and force majeure or the supervening impossibility of performance? Thank you.
Am I on? Let me
Yes,
just say.
Nolthando, you can take it. I'll add when necessary.
Okay. I will take it from the legal side. So reasonability is the Constitutional Court, and a number of cases in the out of the Constitutional Court have set out how the test of reasonability is applied. And I think at the crux is, it's all factors considered. So it's assessed on a, case by case basis. And in the context, looking objectively at what was offered, for example, in that gym instance that you raised, what was offered by the gym and the consumer, and if on assessment, was their refusal unreasonable in the sense that is it not based on a proper assessment of what the offer is? Is it me who's frozen, or is it you, Majeure, is frozen?
I'm not
Hello?
sure. I can hear you.
You can hear me. Okay, so I thought I had been frozen. So in looking at what was offered, what the basis for the refusal is, and on an assessment of the economic, the way in which the relief would have offered a solution to the consumer, on an assessment of all those factors, if it is unreasonable upon conclusion, upon assessment of that, then that's how the test is applied. So it looks at the facts and looks at what's been offered, looks at what the basis and the reasoning for why the service provider is offering, why the consumer is refusing the offer. And that's how the reasonability is assessed. I hope it answers your question. So there's no sort of like mathematical test of if you say yes or if you say no, whatever. It's an assessment of the entirety of the situation, and looking at other economic factors, looking at the context, looking at, what is the industry standard, looking at, does it make sense in the context of the business, from a cash flow perspective? Because I know some businesses were saying we can't give blanket refunds to 2 million consumers. We just simply do not have the cash flow to do that, so all that would be taken into consideration when coming to conclusion that is the basis for refusing truly one that can be regarded as one that's reasonable.
Yes, and I think from the example given, where the gym would say we would charge you 50%, but no service, I don't think that would be the right thing to do. We did not have a problem with gyms that were saying we will freeze and then extend. The only issue there, we said that should be communicated. Any change to the contract, irrespective of what is causing the change, there should be an engagement with the consumer.
And can I add, Majeure, just on that example again? If you are, what we said about raising a force majeure defense is that it suspends obligation on both sides of the consumer and the service provider. So if you're applying that principle in the first place, then you cannot then want an obligation from the other party of payment of 50%, because the principle is implies that everybody's obligations are suspended, which is why places like, I'll just use Virgin, I hope it's okay, they suspended entirely, the obligation to pay because they were not able to perform in terms of the contract, which is to allow you into the gym. Your obligation to make that monthly payment was suspended for those 4 months. They literally took no money from your bank account, and then it resumed. But at that time that it was resuming, they were also then able to perform in terms of the contract, because now gyms were open, and now you had the requisite obligation to pay.
I think I saw a hand from Mike, and then I see Gillian after that. Mike?
Thank you, Majeure. I would just like to have your view on this scenario. Outbound or international tour operator X, when confronted with the request for refunds as a result of travel restriction regulation, has suggested to consumers that, listen, we give you a voucher, and after 2 years, if the restrictions are not lifted, we will pay you your refund, but we will not pay you any interest. And they argue that the objective of not paying interest is to keep the company afloat. Otherwise, they claim they will go under and be liquidated. Now, is this fair to the consumers in this case? Please, can you share your view on this scenario? Thanks.
Okay, section 47, 47.
I think it's 47.3 or 4, yeah.
47.3, okay. If the supplier is not able to supply due to their own fault, they must refund the consumer the amount, if any, paid in respect of the commitment reservation together with interest. That is where the supplier is at fault, right? And then you have 47.5, which says, subsection 3B, in addition, compensate the consumer for costs directly incidental to the breach. Does not apply where the inability to supply is due to no fault of the supplier. And then the other, then it then says that also falls away where the supplier offers an alternative and the consumer does not unreasonably refuse the alternative. So, and our view was also that we need to also be fair and understand that both parties were not at fault and they were impacted. So I don't know what Nolutando thinks, but I think in those instances, it would be a fair offer that consumers could consider.
I agree. I agree.
Gillian?
Thank everybody. Thank you so much for an interesting webinar this morning. I am one of those people that are from the gym industry. And you will also oh no, it's not from Virgin, it's from the other one.
Okay.
And actually it's very, very useful having sessions like this, you know, because it's always good to have a little bit of introspection and have a look at where we might have differed in the opinions. What I want to ask is specifically with regards to the unilateral extension of the contracts. So yes, we froze members' contracts for nearly 6 months. Very difficult to do that, but we did. And then we were given literally 2 days, maybe 3 days to allow our doors to reopen, at which point I think often the companies get hammered by consumers who are often twist the facts. And this is an area that we've really been hard hit by with consumers that often twist the facts. And my question is, what do you consider to be reasonable in terms of the communication with those consumers? I'll give you an example. The minute we were able to reopen, we literally had 2 days to get ourselves ready and reopen. Communication went out to consumers by SMS, by newsletter, by emails, FAQs on the websites, with all the terms and conditions on how things were going to work. How do you freeze? We'll allow you to freeze. What's going to happen to your contracts? And to the point that we've also gone the extra mile by having those engagements and where there's a dispute, coming to a common ground. But I think sometimes it gets overlooked and we get hammered continually with regards to this 5-month issue. So in terms of your opinion on what is reasonable in terms of communicating those changes to a member?
Okay, from what you've said, I think, I mean, you had different channels, and the channels that you used would accommodate consumers that, you know, there are different circumstances, SMS, website. I mean, the ordinary ways in which you usually communicate with your consumers. Yes. What we saw with some suppliers is that they would then say, you need to go to our website to see the changed terms and conditions. And for us, that would be unreasonable because not all consumers have access to websites. When you were advertising, you were throwing it left and right using different channels. And then when it comes to this issue, all of a sudden, the only way you communicate is that there must be a link or they should have gone to the website to check. So those are the instances where we said it's unreasonable, but from what you indicate, it was reasonable in the sense that you had different channels to accommodate the circumstances of your customers.
Yes, correct. Yeah. Yes. So you would consider that then to be reasonable.
Yes.
In communicating the changes to them.
Yes, and the fact that you had also channels for them to be able to dispute or engage.
Yes.
Whereas some suppliers didn't even have that, or even if they had them, they were not manned properly.
Yes. Yeah. Okay. Thank you for that clarification.
Thank you. Well done. Mike, is your hand, is it an old hand?
No, Sis Magauta, it's a new hand. If there are no other questions, can I go?
Yes.
I think Tepiso was next after Gideon.
Okay, I can only see here. Okay, let's go for Tepiso because he did not have an opportunity. Tepiso.
Okay, thank you very much. Thank you very much. Good morning, colleagues, and good morning, Lolitando, Ausmachauta. Very interesting webinar. Mine is on, I'm trying to understand how do you strike a balance between the force majeure clause and the consumer's rights to refund. I mean, in terms of CPA, consumers they are entitled to a refund. So how do you strike a balance between the two? Because that's what we've been battling with during COVID. And what's your view on that? Thank you.
I think, Noltando, let me start. And I think that there is an important thing that we need to understand. The balance of power between a consumer and a supplier, very different. If I've spent 10 Rand as a consumer, it's my 10 Rand. And that's it. What happened during lockdown and COVID is that businesses had access to government assistance. And number two, as good business practice, you would have reserves to cater for instances where you are not able as a business to generate income. Okay, so businesses have access to different risk mitigating instances that would enable them to float them during that time that a consumer doesn't have. So our view was that, yes, we understood that some businesses really could not refund at that specific time. And where that was the case, we would then say, okay, there is a commitment, but that commitment cannot be fulfilled currently, which was the case with some businesses, and we understood it. And we had cases where the business said, I'm willing to refund, but I cannot do that at this moment. I can do it later. Because we also didn't want businesses to go into liquidation, because that impacts the economy, that impacts individuals, that impacts job losses. So, but the only thing we said that you could not just unjustifiably say there was a force majeure and it automatically applies, because like Nolutando says, it has to be in the contract. There has to be an objective assessment of the impossibility. We have to look at mitigating circumstances to be able to come to a conclusion. What we saw with some suppliers is that they were just relaxing and they said, it's a force majeure, sorry, there's nothing we can do. That is the end of the story. And that is where we had an issue. But somebody who came to us and engaged and said, this is my situation, here are my books, financially, it is not possible. And we know some businesses went under. So that balance was there. But some businesses wanted to use the circumstances as an excuse to just walk away without any consequences on their side. Noluthando, you can.
Yeah, and just to clearly illustrate the difference between the obligation to pay the refund and a force majeure. So all force majeure does is alleviate, absolve the person from a damages claim. So ordinarily you'd be liable if you don't perform in terms of a contract. You'd be liable to a damages claim by the other person who would sue you and say, you were supposed to give me a bicycle, you didn't, I sue you for a damages claim for non-performance. So force majeure has the legal effect of protecting you from a damages claim that should ordinarily have ensued but for the force majeure, right? Or the force majeure defense. But what Section 47 does is entitle legally a person who has paid to get their money back or provide alternatives. And obviously the consumer cannot unreasonably say no to that alternative. So that obligation is not obviated by force majeure. That obligation to repay money you were given, unless obviously like Mema Gauta says, circumstances where business comes and says, or business opts, for example, to give vouchers because of they were inundated by claims, for example, airlines inundated by claims for refunds, and they wouldn't have stayed afloat, some of them, or some organizations would not literally have stayed afloat if they had to give back all the money that was given. In that instance where they give vouchers or make alternative arrangements, postpone payment, etc., that all is reasonable. But there is a distinction between the legal effects of force majeure and the legal effects of CPA. And I think that those decisions, and what was happening was that businesses were trying to conflate the two, and they are not the same thing necessarily. Yeah.
Yes.
I hope that's clear.
Okay, thank you. I think we can go to Mike, back to Mike.
Thank you. It's still the Tony issue of refund. Now, we've got a situation where you've got a booking engine. Then on the other hand, you've got a service provider like a guest house. Now, with cancellation, prior to COVID, we knew that when there was a cancellation, then we go to the booking engine. Since COVID-19, when there's a cancellation, the booking engine will say, for a refund or a request for postponement, talk to the guest house. Then the guest house, in some cases, they just refuse to take any suggestion for a postponement. And if you ask for a refund, they say, no, go to the booking engine. So like consumers are being pushed now between
Yes.
Yes.
I think that issue was most common in the airlines industry, because a lot of consumers booked through booking agents who are then responsible for paying over the money to the airline. And in those instances, unfortunately, it is the airline who had to refund, because the money was with the airline, not with the booking agent, unless the booking agent had not yet paid over the money to the airline or to a cruise ship or whatever. Then the booking agent would be responsible for paying the money. But our view was that the booking agent was still responsible for following up with the airline, not the consumer, because that was their responsibility. They did the booking, they paid over the money. It is their responsibility for them to engage with the airline on behalf of the consumer, not to say to the consumer, no, we are not responsible anymore, you need to talk to the airline. That one we did not agree. They still had to play the role of the middleman to ensure that at the end of the day, the consumer came right. So you cannot say I'm an agent and then I wash my hands. No, in that sense. Noluthando, I don't know if you have anything to add there.
Oh, no, I think you've adequately covered it.
Okay.
Gillian, is that an old hand, or do you have a follow-up question?
Okay. I think we've answered all the questions. Am I right?
Are you covered, Gillian?
Yes, I'm covered.
Okay.
Okay.
Thank you.
Okay, Noluthando, thank you so much. This was really an awesome presentation from you, very informative. And thank you also for responding to the questions. And thank you to everyone who attended today. We are all learning. I said that the CPA was not drafted with the pandemic in mind. So who is that? It says they have a question that was missed. Daisy. Oh, Daisy asked, what section of the contract can we find the clause? I mean,
okay.
yeah.
Yeah, ordinarily, for example, all the contracts I've seen, from big firms, etc., there will be a clause right at the end, after payments or whatever, that will have, where it has clauses around notices and a severability of contract. Towards the end of the contract, there should be a clause. Usually it's titled force majeure, and it defines the force majeure, or you can look in the definitions. If it's a contract that has a definitions clause, look there if there's a force majeure definition, or if it's in PDF or Word, just do an Alt F and look for force majeure. If it's there, those words would definitely be in that contract, but it might not be. So if you don't find it, it doesn't mean something's wrong. It might not have been in the contract, in which case, as I said, you would then have to rely on the supervening impossibility doctrine.
Thank you. As I was saying, thank you everyone for attending this, our first webinar, where we would engage on legal issues that arise out of the complaints that we receive. Like I said, the CPA was not drafted with the pandemic in mind. So we have to look at each case on its own merits. We have to look at the principles that the consumer protection is advancing, even though it's not to that specific issue. And we also have to look at the common law. So yes, I mean, we will continue to engage and ask the questions, and we look forward to inviting you to the next webinar. I mean, this is our first, so I think I see about 61 people. And yeah, you can also suggest topics that you think the Ombud should cover. Noluthando is in trouble. Yeah, and as we continue to learn together, I mean, like someone says, there has to be a balance between consumer rights and supplier obligations. And at the end of the day, we want to come up with solutions where everybody's rights and obligations are protected. Thank you so much. Looking forward to seeing you at the next one. If you have feedback for us, please don't leave without sending us a chat so that we can see if this was useful to you. Thank you so much, and bye-bye.
Thank you.
We will definitely put the presentation on our website, and we will send out a link. Thank you, everyone.